All right, let's get into the very messy topic of exemptions. So, we've been talking about those people that are not exempt from overtime, right? That are often paid hourly, they clock in and clock out. We know we have to pay them minimum wage and overtime. Certain employees are exempt from the minimum wage and overtime requirements, right? Hence, exempt employees. This can get very messy, but I'm going to focus on the pieces that I think are most important. And that's the so-called white collar exemptions, right? Your executive, administrative, and professional employees. Now, as many of you have probably heard, and this is one of the questions that was submitted, the Department of Labor back in April announced a final rule to increase the compensation requirements for who is exempt or not exempt from overtime. Okay. Currently, in order to be exempt from overtime, there's a two-part test, right? We look at your job duties and what are your primary duties. And then we look at how much you get paid and whether you're being paid on a salary basis. Currently, the minimum salary is $684 per week, which amounts to $35,568 per year. What we see a lot of people do wrong here is they say, okay, I'm paying so-and-so $36,000 a year. They're automatically exempt from overtime. Again, it's more complicated than that because in addition to how much they're getting paid, we also have to look at their primary job duties. What the Department of Labor announced back in April was that rate is way too low and it hasn't changed in I forget how long. And so effective July 1, so a couple days now, that is going to increase to $844 a week or $43,888 a year. Most of the clients I've talked to, not too concerned about that jump. The thing that's got everybody up in arms is that they also announced beginning January 1, 2025, that rate is going to jump again to $1,128 per week, which adds up to $58,656 a year. And so what we're seeing with a lot of small businesses is, okay, if I've got somebody, they've been exempt from overtime, I'm paying them $45,000 salary a year, I'm not too worried about this announcement. And then they said, okay, and then on January 1, it's going to jump again. And they went, whoa, 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 whoa. I'm not going to increase somebody's salary from say 45,000 to over $58,000 in 1 year, right? So those people that are kind of caught in that middle ground, you're going to have to make a decision about. Do we increase their salary enough to meet the new salary requirements? Or do we convert them to non-exempt and start paying them hourly and keeping track of their hours and potentially having to pay them overtime if they work more than 40 hours a week? So there's no pretty way about this, right? You really just have to do the math. You have to look at that person, and it's going to be tough because if they've been paid a salary to this point, you may not have a good sense of how many hours a week they work. So you're going to have to look at, okay, how many hours a week do they work? How much of that's potentially going to be overtime? If I keep them at this rate of pay divided by that many hours, this is what that hourly rate's going to be. But now I've also got to factor in, are some of those hours going to be overtime at time and a half? So that's where it gets a little bit messy. To the extent your people are paid more than that, this isn't going to be a concern, at least not right away. But that was the big announcement. Now, these increases to the salary basis only apply to the most common exemptions, which are your white collar exemptions, your executive, administrative, and professional employees. They also increased the threshold for what we call highly compensated employees. Most of my small business clients are unfortunate enough to be in that boat, but that's also going to jump up well over 6 figures. So that's what's going on with the new rule. Where the other place that this gets messy is that the Department of Labor has been trying to do this since at least 2016. Every time they've tried, there have been lawsuits filed. So far, the courts have kind of kicked it and said, no, you can't do that. So that can create some mess there. Currently, I think last time I checked, I've seen at least 4 or 5 lawsuits that have been filed against this salary increase. Haven't seen any court rulings on it, so we don't really know what's going to happen. Right now, I tell clients, let's work under the assumption that the increase on July 1 is going to go into effect until we hear otherwise. I would also tell people to go ahead and start preparing for the increase that's going to go in on January 1 until we hear otherwise. There have also been at least a couple proposals in Congress to try to take this away from the Department of Labor and say, hey, if you want to increase the salary requirements, that has to get congressional approval. Again, none of that is actually passed, and so that's not the current law of the land, right? So again, this is why it's so important to have a relationship with an attorney for your business, because some of this stuff changes very rapidly, right? What I'm telling you today could very well change at the end of the week before July 1 rolls around, or it could change shortly thereafter. We just don't know yet. So if that is not confusing enough, let's see here. We got a couple questions coming in. Somebody commented their past employer withheld pay even after giving them 30 days notice because they had that in their employee handbook. Yeah, I'd say that's a walking lawsuit waiting to happen. And lawsuits are incredibly expensive. I wouldn't advise anybody to put their business in that situation. Do you have any advice on how a Christian counseling center can ask employees to acknowledge or sign a statement of faith document, or other ideas on how to uphold the counselor's moral expectations? That is one. Gosh, let me see if I've got some time at the end of this to try to come back to that. I just want to double check something before I try to answer that question. There are certainly some ministerial exemptions to some of the non-discrimination laws, and that's where that issue would come up. Wasn't the thing I was planning to talk about today, so I don't want to give you the wrong answer just speaking off the top of my head. What I'm wondering about from a legal standpoint is to what extent that applies outside of some of your church settings. And I know it does. Like I said, I just don't want to articulate the wrong rule there without actually looking at my notes. Okay, so then the other question, so anyone who is on a salary needs to meet the minimum January 1, 2025 number. And what about for the higher paid positions? So again, this is where it's messy. Anyone who is on a salary that you are also relying on the executive, administrative, or professional exemptions needs to meet the January 1, 2025 number. Remember, in order to be exempt from overtime, you have to meet both a primary duties test and a salary basis test. So I'm assuming just by the nature of therapy practices, right, we're talking about one of those white collar exemptions that we're about to get into. So assuming they meet one of those, and that's what you're relying on, then yes, they need to meet that January 1, 2025 number in order to remain exempt. Otherwise, they're going to become non-exempt. I'm not sure what you meant about what about the higher paid positions. You know, like I said, there is another exemption for highly compensated employees, but that number is somewhere around $107,000 a year. Most of my small business clients don't find themselves paying that kind of salary.
Yeah, I asked the question. I can kind of clarify it a little bit.
Sure.
So Green Oak Accounting sent out something, and while our admins don't get paid that amount, we have a clinical director who is going to get paid 100,000. And so I'm just wondering if her salary also would need to be increased. Or in general, like if none of these people are working over 40 hours, does it matter?
If nobody's working over 40 hours and you know you're paying them at least the minimum wage, then it probably doesn't matter, right? Because what we're saying they're exempt from is the overtime requirement, right?
Okay.
So that's really where that comes into play. The person that's making 100,000, I mean, again, assuming this isn't what we're concerned about, there's still the question of do they meet the primary duties test to be exempt from overtime? But again, if nobody's working more than 40 hours a week, we may not be concerned about that. Okay.
Okay. That's
And then, of
helpful.
course, legal asterisks, does your state or municipality or where that employee happens to be based say, hey, we're also going to require overtime if they work, say, more than 8 hours a day. But right,
Mm-hmm.
that's where we get into some of those nitty gritty issues that I'm not going to be able to give everybody an answer for every state and city.
Okay, so in theory, if I make it so that everybody, I can find like for my state and city more specifics, but if I make it so that everybody works, 8-hour days or less, stays under the requirements, and they're clocking in and clocking out, there would be no issue.
Yeah, so then there's no issue, right? And for those people, I say, make sure they're clocking in and out, because as we'll talk about, you've got to have those records, right, in order to be able to prove that they really didn't work more than 40 hours in a week.
Yep, perfect. Okay, thank you.
Yeah, no problem. Okay, so let's talk a little bit about the exemptions. Like I said, I'm going to focus on the most common ones, which are the so-called white collar exemptions. Actually, hold on. Before we do that, let's finish talking about the salary basis. So you got to meet a primary duties test. We'll talk about that in a moment. You've also got to be paid on a salary basis, right? As we talked about this week, that is a minimum level of 684 per week. So what does that mean? Salary basis means they are paid a set amount per week with no deductions based on the quality or quantity of the work performed. So if they do any work that week, they need to be paid at least $684 that week. There are some deductions that are permitted, right? Obviously, you're allowed to take out payroll taxes. You are allowed to deduct for a full day absence for personal reasons outside of sickness or disability. So if somebody says, hey, I'm going to take this day off for vacation, you are allowed to deduct for that full day. If they say, hey, I'm going to take an hour for personal time to go run to an appointment or my kid's school thing, you're not allowed to deduct for that. You are allowed to deduct for a full day absence for sickness or disability, provided that you have some sort of bona fide health and welfare benefit plan, policy, or practice of providing compensation for those absences. That is the law's very convoluted way of saying if you have some sort of paid sick time or paid time off policy and somebody says, hey, I'm going to take an hour to run to the doctor's appointment, right? Or if I'm going to take off the entire day, I'm way too sick to work, and then they run out of their bank of sick time, then you are allowed to deduct for that full day absence. You can offset amounts that they get for jury duty or witness fees, which are usually so minimal as to be laughable. You can offset for amounts that they receive. Say, I can't work for you this, Monday and Tuesday because I've got to go do this thing for the National Guard. So whatever the military pays them, you can offset their salary for those 2 days. You are allowed to impose penalties in good faith for infractions of safety rules of major significance. We don't typically see this in office settings just because you don't tend to have major safety rules like you would on a construction site. You are allowed to do unpaid full-day disciplinary suspensions imposed in good faith for infractions of workplace conduct rules, right? So this is the, hey, you've violated our policies, on harassing a coworker, you're going to be suspended without pay for 2 weeks, right? Something like that. That's fine. Certainly you're allowed to prorate a person's salary for the days that they don't work during their first or last week of employment. So new kid starts on Wednesday, right? They're going to be paid salary. You don't have to pay them the salary for Monday and Tuesday that they didn't work, and vice versa for, that week that their employment ends. And of course, you can deduct, insurance premiums, contributions to 401ks, retirement plans, those type of things. Now, one of the questions that comes up, saw it in here somewhere. Don't see it at the moment. What about paying people on a fee basis? If you are relying on the administrative or professional duties exemptions, you are technically allowed to pay people on a fee basis. However, the rules are so convoluted and messy that I don't advise it. Fee basis is the employee is paid an agreed amount for a single job, regardless of how much time it takes to complete that work. And the fee is at such a rate that if they worked 40 hours in a week, it would have added up to that minimum salary of $684. Okay. So the classic example is if you're paying an artist $350 to work on a picture or movie or something, and it takes them 20 hours to complete it, that would meet that minimum $684 weekly salary amount. Because if you took that rate, and said, okay, what would that amount to if there was 40 hours a week, the math would add up. The problem with relying on fee basis is that a fee is paid for the kind of job that's unique and not something that you're just repeating over and over and over again, like say a 1-hour therapy session. So when you run into that situation where, hey, I'm paying you the fee based on time, a 1 hour therapy session, or I'm paying you a fee to do the exact same job over and over and over and over again, it's no longer a fee basis. You're just trying not to pay salary, and the law doesn't permit that. So that's where I tell people to, that whole fee thing can get real messy. The other thing I've seen therapists sometimes do is they'll do a minimum guarantee and then some, right? So they'll say, hey, I'm going to pay you the minimum amount for you to be salary basis under the law. And then we'll work out some compensation structure where you're getting, say, bonuses for a percentage of what we get back from insurance, right? Or, this set amount from the insurance reimbursement. That is permissible, again, as long as they are getting at least that minimum salary basis, okay? And you need to be paying that salary basis as a salary, right? So it's still you can't take deductions from it. You can't say you didn't see enough clients this week. You can't do any of those sort of shenanigans. So that would be one way to possibly do it. Like I said, the more creative you try to get with pay, the more complicated some of these things can get. There's a question about when employees have to be paid, and can you wait until the payment comes in from insurance, which can take 1 to 2 months. From a legal standpoint, every state has some version of a Prompt Pay Act. It's not incorporated into the federal Fair Labor Standards Act, but every state has some version of it. And so that's going to be very state or even sometimes municipality specific. Here in Ohio, it's basically the 1st and 15th, unless there's some agreement to pay otherwise. And so again, that can get very messy. I tell everybody, from a recruiting standpoint, you also have to consider, if you're putting your cash flow and your collections issues on your employees, are you going to be able to recruit good people to work under that condition, right? So that's not a legal issue at that point. It's just a matter of, will somebody, if it's permitted in your state, will somebody actually agree to, I'm going to do the work today and possibly not get paid for 30, 60, or 90 days. Do employees still need to clock in and out if they're paid hourly for clinical sessions? All the hours are logged in their EHR system. It really, that's a question of, I'm going to assume in that case that they're not exempt from the minimum wage and overtime requirements. The requirement is that you as the employer have the records, right? You have to be able to show these are the hours that they worked and this is the time that we paid them for. Okay. So as long as you have the records somewhere and those records are accurate, you're fine. The issue I see people running into is they don't keep the records. They've only got partial records. We got the records for the clinical time, but we don't have the records for the time they spent on notes. We don't have the records for the time they spent in team meetings, right? We don't have the records for the time they spent doing all these other things. And when the employee challenges you on that, you will lose. It is your job as the employer to have the records. Another common one, is it okay to pay the same employee one rate for therapy and another rate for admin services? Absolutely. The law doesn't say that you have to pay the same amount for all types of work done. The law just says that you have to pay them at least minimum wage. So really quickly, so we've talked about the salary basis. We've talked a bit about pay. As I said, it's not enough to pay people salary basis. We also have to make sure they meet one of the duties tests, right? So what is their primary job duty? What is the principal, main, major, or most important duty that they perform? That is going to be a very fact-specific inquiry. As I said, different courts, different judges are going to come to different questions and realizations. Different administrative bodies are going to have different questions and realizations.